Our next contributor is Professor Henriette Roscam Abbing, and she was one of the pioneers of Dutch and European health law. She worked for the Council of Europe Public Health Department and combined her professoriate at the Universities of Maastricht and Utrecht with the position of legal counsel in health law to the Ministry of Health in the Netherlands. She is a member of the editorial board of the Dutch Journal for Medicine and served there for 25 years. She was chair of a Netherlands Committee on Genetic Science and Society, formulated a committee specifically formed for that committee, and also was involved in the drafting of legislation in the Netherlands relating to medical examinations in the context of employment. So it gives me great pleasure to call on Professor Henriette Roscam Abbing to make her contribution on the case for a European regulatory response in the context of benchmarks, in the context of Council of Europe norms on genetic discrimination.
Thank you very much, and thank you for giving me the opportunity to present my experience with particularly the Council of Europe in the field of medical examinations for insurance and employment. You will excuse myself because I'm not English native, so sometimes I will not have the right pronunciation. As you will see, the focus of my presentation will be on the Council of Europe human rights standards in relation to medical examinations or health assessment, whatever you want to call it, for private insurance and pre-employment. Medical examination includes also asking health-related questions. Human rights concerns around the issue are not limited to discrimination, so I will give you a broader perspective. And whenever relevant, I will also refer to the European Union Fundamental Rights Charter because of the European Union adherence in the near future to the European Convention on Human Rights. But for the rest, I leave the European Union outside. I will concentrate on tests that aim at detecting a latent, serious, incurable disease, and that is the case of HIV infection, at least it was at the time, and predictive genetic testing, which includes susceptibility, genetic predispositions, and genetic dispositions. And the third issue is the use of genetic information as a result of already known, the use of genetic information results already known by the testee about, for instance, his family members. The layout of my presentation is first the relevant texts of the Council of Europe in a historical perspective. Then I will give you some basic assumptions on the activities of the Council of Europe. I will deal with the relevant European human rights frame, both individual and social. And then I'll come to the non-discrimination principle. I will deal with some case law and then will end with the question why a common European standards is a matter of urgency. Now, when we look at the activities of the Council of Europe, there is over 20 years of activity already in this particular field. In Europe, the discussion on medical examinations were started for a number of reasons, and that was mainly because of the new medical technological possibilities which enabled the early detection of serious incurable disease, as well as the collection of predictive prognostic information on future health and life expectancy, and on susceptibilities to environmental and other conditions. And there was a growing awareness at the time already that if not properly used, those developments were likely to have adverse effects. And this particularly when use is made of medical examinations for non-health related purposes. There's a number of texts at the intergovernmental level of the Council of Europe which is relevant for the subject matter. And they have a variety of angles of incidence. You'll see them here. I will not enumerate them all, but I'll just give you, in a sense, the core of these texts taken together. As to employment, the texts all come back to the point that no medical assessments should be used as pre-employment selection method, except when this is justified for health reasons of the person concerned or of third parties. And we have heard this morning in the USA, there's a similar discussion. Insurance. If they have a social function, there should not be predictive tests. Asking for the results of previous examinations was prohibited. No collecting and processing of genetic data, except for health purposes of the data subject or for scientific research. And there might be a case of overriding interest. I'll come back to that. And no collection and processing of sensitive data, health and genetics in the context of profiling, unless necessary for a lawful specific purpose. Now, next to these recommendations, there is the 1997 Convention on Human Rights in Biomedicine that prohibits the use of predictive genetic tests unless for health purposes or scientific research, Article 12 of the Convention. And the same holds for the protocol concerning genetic testing for health purposes of 2008. So the protocol and the Convention exclude genetic testing as an instrument for purposes of selection in every other field unless for the health of the individual. And in the explanatory report, the reason is explained. Because there's an apparent risk that use is made of genetic testing possibilities outside healthcare, for instance, in the case of medical examination prior to an employment or insurance contract, it is of importance to clearly distinguish between health purposes for the benefit of the individual on the one hand and third-party interests which may be commercial on the other hand. But the Oviedo Convention also contains an article which allows for an exception to the prohibition. Namely, exceptionally, a test predictive of a genetic disease may be performed in the interest of public safety, for the prevention of crime, for the protection of public health, or for the protection of the rights and freedoms of others, provided it is prescribed by law and necessary in a democratic society. Now, the protocol to the Oviedo Convention, the protocol on genetics, does not contain very specific clauses for the subject matter we have under discussion. There's one relevant clause which says that respect for private life, in particular data derived from a genetic test, then there is a protection when somebody has results of a genetic test in the context of healthcare, that it should not be used for other purposes. The protocol does address genetic testing in relation to the working environment, but only for health reasons of a prospective employee. So, taken on the whole, the protocol does have little significance for medical examinations for non-health purposes. Finally, at the moment, there is a working group of the Council of Europe Committee for Bioethics who is preparing a document on predictivity, genetic testing, and insurance. And a green paper on this subject will circulate beginning of the next year. I also have to mention a report which was published in 2000 on medical examinations preceding employment and private insurance, a proposal for European guidelines. It was the intention at the time to have a recommendation on this issue, but for some reasons it didn't reach consensus, so finally they decided to publish the report. And this report is very pertinent to the discussion we have here today, and you can find it in the European Journal of Health Law of June 2000, the number 2 of that year, if you are interested in it, of course. Now, the message of the Council of Europe is that medicine is increasingly used as an instrument for distribution of so-called social goods, and that in particular in relation to work and private insurances, whenever there are conditions for subsistence, of course. Now, when medical examinations and health assessments are required in relation to the so-called basic needs, there's an element of compulsion. The medical examination is voluntary in theory, but unavoidable in practice. And the medical examinations under discussion not only touch upon social rights, but also on human dignity, respect for private life, and they can result in discrimination. If used for non-health purposes, the medical examinations can discourage people to make use of necessary healthcare services. And this is particularly of concern with predictive testing and the collection of information on fatal diseases without prospect of treatment. And that is notably the case in the field of genetics. But the discussions around HIV show that non-genetic situations should not be excluded per se. Now, when private insurances involve social attainments, when they represent basic social needs, a balance should be struck between the justified needs of the individual and the justified interests of insurance companies to prevent adverse selection. In relation to employment, a health assessment ought to be in the benefit of the employee and not for the financial health of the undertaking. Therefore, pre-employment medical examinations should only be performed when there are special job-related requirements. And this is all what you can find in the documents of the Council of Europe. Selection of job candidates on the basis of medical examinations should not replace the duty of the employer to take effective preventive measures for healthy working conditions. And that's a statement of November 2000 of the European Society of Human Genetics. Now, medical examinations more in general should comply with certain conditions. Medical examinations and their objectives should be justified. What is asked and examined should be relevant, necessary, and proportional to those objectives. Information collected should only be used for the objectives concerned. There are generally accepted principles, at least in the legal sense. I now come to the individual human rights, to the human rights which are involved in the situation of medical examination for non-health purposes, and then particularly private insurance and employment. The medical examinations that are necessary for the purpose of social goods, for subsistency, increasingly pose a potential threat to social as well as individual human rights. Now, the individual human rights involved are notably the right to protection of private life, the right not to know, and informational privacy, the protection of the physical integrity, and the data protection in relation to informational privacy. And you'll find that in the European Convention on Human Rights. In the Convention on Human Rights in Biomedicine, the Oviedo Convention, it comes back under the condition of free informed consent for any medical intervention, and in Article 10 in the respect for private life. And when you just look at the European Union Charter of Fundamental Rights, you'll find the same notions back in the right to respect for physical and mental integrity, respect for private life, and the right to respect of personal data to be processed fairly for specified purposes with consent or for some other legitimate basis laid down by law. And all those human rights, as they are formulated, are relevant for the medical examinations. But also social human rights are involved. The European Social Charter contains rights because they cover adequate means of subsistence. So it gives entitlements, for instance, to work, to safe and healthy working conditions, to health protection, to social security, and the right to social and medical assistance. And some other rights, including, for instance, housing and benefit from social welfare services. Now, the Oviedo Convention also contains some social rights. You'll find it notably in Article 3, the equitable access to health care. And here the expected effect of the prohibition of predictive genetic tests in the Convention is that it may take away the negative impact of those tests if used for non-health purposes on the use of healthcare services, because people fear the use of the outcome of tests to be used for unjustified purposes. They fear to go to the healthcare services because they don't trust in the data protection. And then after the Oviedo Convention, we still have the European Union Charter on Fundamental Rights, which covers the social security and social assistance as a social right, healthcare, access to services of general economic interest, which is of importance the more insurance gets a social purpose, and the high level of consumer protection. Though there's a whole host of human rights, individual and social, which in principle can protect the individual and should protect the individual against the abuse of medical examinations for non-health purposes. I now turn to the prohibition of discrimination, which also is included in the human rights instruments. The right to be protected against unjustified discrimination is important for the subject of discussion, both in the social and in the individual sphere, as it protects against unjustified discrimination. And here I want to stress that discrimination is not a principle that stands alone. discrimination as a consequence, discrimination is a consequence of a breach of individual human rights, like the right to privacy. And discrimination causes breach of social rights. When one is discriminated, it can have effect on, for instance, in the discrimination sphere, on, for instance, the right to housing, but also the right to have a social insurance in the private sector or to have employment. So discrimination is something which stands in between the other relevant human rights. Now, the non-discrimination Article E in the European Social Charter includes non-discrimination on grounds of health. Differential treatment based on an objective and reasonable justification is, however, not considered discriminatory. And the European Convention on Human Rights, non-discrimination Article 14, is related to specific topics, but the grounds mentioned in that article are not exhaustive. And the protocol to the European Convention on Human Rights, protocol number 12, also contains a general prohibition of discrimination, so it's not ground-related. States have an obligation not to discriminate against individuals. But there's room also for states to take positive action in order to prevent or to remedy discriminations between private persons. Relations in the public sphere, normally regulated by law, for which the state has a certain responsibility, for instance, arbitrary denial of access to work or to services, which private persons may make available to the public, such as medical care. So here you see that the non-discrimination clause has also certain horizontal effect. It's not only a state's duty. And then we have the Oviedo Convention. It has been said already before, where Article 11 prohibits discrimination on grounds of genetic heritage, and there's no restriction allowed for under this article. However, the nature of the situation that amounts to discrimination in this respect is not very clear. Finally, we have Article 25 in the European Union Charter on Fundamental Rights, which refers to genetic traits, but not to health. But like Article 14 in the European Convention on Human Rights, also Article 21 of the Charter is not exhaustive. And also important is that the prohibition in this article is not confined to states, but it also creates a horizontal obligation. Now, it's important to look at the enforcement of the human rights instruments, because human rights instruments are nice, but when they remain declarations without enforcement mechanisms, they don't serve really a great purpose. Now, under the European Convention on Human Rights, we have the European Court of Human Rights, which might be known to you. The Oviedo Convention does not have really an enforcement mechanism, but the European Court of Human Rights is using the Oviedo Convention in its own judgments. So indirectly, the Oviedo Convention is enforced through the European Court of Human Rights, which is important. And another important aspect of the European Court of Human Rights is that it also deals with social aspects in its judgment. The court has indicated already a long time ago that there's no watertight division separating the sphere of social and economic rights from the field covered by the European Convention on Human Rights. While the Convention set forth what are essentially civil and political rights, many of them have implications of a social and economic nature. And this relates inter alia, according to the court, to social welfare. And this was a court case already in 1979. Other examples are of the European Court of Human Rights in relation to social rights are the payment for medical treatment, social welfare, guarantee of standard of living, and also the discrimination. Now, the European Social Charter has a reporting procedure to ensure compliance with obligations of governments. But there's also a possibility of bringing forward a collective complaint. And in cases which came under this procedure, the cases had to deal with the adequate level of social protection, with housing, and also with discrimination. So there is already quite a lot going on in the enforcement sector. Now, the European Union Charter on Fundamental Rights is enforced primarily through the European Court of Justice as the competent instance, but there is also an influence of the European Convention on Human Rights as soon as the European Union has adhered to the European Convention, and in that case the Charter only takes precedence when it provides for more ample protection. So the European Court of Human Rights has a large area of jurisdiction which it gained in the course of time over social rights, but also over activities activities by the European Union which are brought before the court. Now, a recent judgment of the European Court of Human Rights, which is of particular interest for our today's discussion, is the judgment of 10 March 2011 in the case of Guillotine versus Russia. And there is quite some room for analogy, can't find the word, never mind, for looking at this case to transpose it to the discrimination in relation to genetics and other status in respect of medical examinations for non-health purposes. It really is a landmark in the court jurisdiction, and you'll see why. The case was about discrimination in relation to HIV status. The Russian regulation did not allow to provide a residence permit for a foreign national unless the individual shows proof of negative HIV status. So the person concerned went to the court, and in its judgment, the court cites extensively from international human rights documents, and notably those from the United Nations. For instance, if other status is mentioned in non-discrimination clauses, it is said in the UN resolution of 1995-44 that covers health status. The second citation was from the UN General Assembly Declaration of Commitment on HIV and AIDS from 2001, elimination of all forms of discrimination and ensuring full enjoyment of human rights, including access to health care, employment, social and health services, privacy and confidentiality. So here, access to health care, for instance, and the health services is important. And then The court also refers to its recent recognition that physical disability and various health impairments fall within the scope of Article 14. And moreover, and here comes something important, in the views of the court, the existence of a European consensus is a possible additional consideration for determining whether a state should be afforded a narrow margin of appreciation or a wide one. And European consensus on the medical examinations for non-health purposes could, in principle, also fall under this view. Where there is a common standard, according to the court, which the state has failed to meet, this may constitute a relevant consideration for the court when it interprets the provisions of the Convention in specific cases. And this is something what the court never before, in fact, has pronounced. Now, why is it important to stimulate the discussion on standards once more? Once more, because it was already a subject of discussion 20 years ago. Advances in genetic technology like full genome sequencing, pharmacogenetics, broaden possibilities for the benefit of the patient. But at the same time, the present economic financial difficulties in European countries with high level of unemployment are an extra incentive for private parties to make use of possibilities of medical examinations for non-health purposes. Private insurance with a social function. The social function of private insurance is drastically increasing. Private insurance is no longer a luxury when it comes to health and life insurance and collective employment-related insurance schemes like disability and pension schemes. Employers have increased commercial interests given the unemployment rates. They have a more flexible playfield to use medical examinations and select job candidates on their health status. And the same applies for the eligibility for work-related insurances. Then there are public health consequences. Fear for use of medical examinations, including existing information as a selection method for non-health purposes, discourages access to health care. It has been said several times today. But also it discourages participation in useful medical research like pharmacogenetics. And this clearly runs counter to the social right to care for health. Now, why should we have standards? With a diminished public safety net, scarcity of social goods, guarantees for subsistence through the accessibility of essential services, health and other social services in the private sector are essential. And the use of medicine as an instrument for distribution of social goods is much more a real threat than it was 20 years ago, nationally, but also at European level. Basic social services must be accessible to all. And here governments have a positive obligation under human rights instruments. Why European standards? It is shown in the 2000 Council of Europe report I already mentioned and confirmed in later studies that diversity in regulation, if there is any regulation, among member states outrules uniformity. In European countries, the issue under discussion are not coherently addressed. If they are addressed at all, they differ in scope, means, and effectiveness. Legislative and other actions by individual states in Europe cause distortions in the internal market and consumer protection. It creates a variety of restrictions to the free insurance market and to employment. And this together with the important cross-border commercial service provision, cross-border employment, and patients' movements, makes it more urgent to have a common set of European principles. And one may add to this the electronic health data exchange, which of course also goes cross borders and which is a possible threat to the privacy. Now, when the social structure fails to meet basic needs, European standards for the collection and use of sensitive health genetic information for insurance and employment are urgently needed to put a halt to and prevent further social exclusion and disproportional interference with individual and social human rights. Now, the objectives of such standards should be to improve the legal position of the person subjected to medical examination, to prevent adverse effects of unlimited use of medical knowledge, and to guarantee participation in social attainments. And finally, I assembled some statements which show why standards are necessary elements to give effect to the objective of the EC Treaty, to give effect to the 2009 statement of the European Committee of Social Rights, and then the 2011 statement conference on the occasion of the 50th anniversary of the Social Charter. And last but not least, the rules of the European communities should be human rights proof, and that is also an important obligation. So I hope I have given you some ideas for further discussion. Thank you.